I'm Shauna Fleischbein with Castle Group, and I'll be moderating today, kind of looking through all of your questions as Sean Brown takes us through his presentation here and enlightens us on good old cyberbullying, so in social media, the great things of our current world. So Sean, I'm going to hand it over to you and let you introduce yourself.
Thank you, Shauna. I'm Sean Brown, K-Bender Rimbaum. I'm in the Tampa office, board certified in condominium and plan development, and highly active with the Florida bar, legislation, continuing legal education. So we're here to address a hot burgeoning topic that has no clear answers.
Exactly. Oh, go ahead.
Okay, just like a lawyer, no clear answer.
Exactly, right? It depends.
Exactly.
So, well, I'll let you go ahead. I know you have a presentation, so I'll let you go ahead and share your screen, Sean. And for all of you watching, I will tomorrow be sending an email to everyone, which will include Sean's presentation that he's doing today, his slide presentation, which I'll send via a PDF. And I will also send a recording of this presentation or a link to the recording, so you can either refer back to it or you can pass it along to, you know, fellow board or committee members. So you'll have all that, and like I said, I'll email that out tomorrow along with Sean's contact information. So go ahead and let's get started, Sean.
So let's begin with what is a hot trend in our world, unfortunately. Everybody being badgered by keyboard commandos. So we're going to take this from a very broad sweeping area. There's harassment, cyber stalking, which also has cyberbullying, defamation and slander, and community associations, or as I like to say, everything you say can and will be used against you. And unfortunately, it's not in a court of law, it's in a court of public opinion. And often really that court of public opinion is cyber-based. We're going to go through the materials somewhat quickly because I want to get to your questions. You're going to get this PowerPoint at the end of the program. You can review it at your leisure. You can email me if you have any questions about anything in here, because I sort of feel like a myth buster for those of you that remember the show. What you think the law is and what it really is are vastly different. So let's get started. This seems to be the general state of discourse in our world today, unfortunately. And if you're on the board of directors, you're used to this. So let's have an overview of the current law and all the different forms of social media and cyber communication that come in. So defamation and stalking, it's a burgeoning area of the law. Claims are rapidly growing. You know, from about 5 years ago, you saw maybe 1 or 2 of these. I probably now get 4 to 5 of these per week, calls about the issues with there. It's an issue that community associations are facing on a daily basis, just given the nature of community living. And despite the efforts of the legislature and judiciary, the law is not going to go as far as you think it does. The law defaults to the idea that we want free speech, free discourse, the ability to kind of say what you want. So it's easier to defend these type of cases when they come across, given the high burden of proof. And as you'll see, there's just a ton of defenses. So as we all know, Florida's unique. It's its own little island of fun. So let's get to harassment in Florida. Everybody talks about, I'm being harassed. Well, interestingly, Florida doesn't recognize harassment as its own separate crime. And you're going to see the word crime here, because that's where this comes about. And the crime element is what underpins the ability to get the injunction or restraining order that lets you address these type of issues. It's really a criminal type component with a civil undertone. So harassment's really a category that's part of stalking. And you see we have a stalking reference there for you in the statute. So what is stalking? You have to willfully, maliciously, and repeatedly follow or harass the other person. And as we'll get into it, there's a very specific issue with course of conduct that's causing emotional distress. And you're going to sit there and think, well, that person's harassing me over and over and they're causing me distress. As you'll see, it's not what you think it is. It is a high bar to clear to get anywhere down this road. So what do we have? Generally, what we have in our lives is a failure to communicate. And the case you can read on your own, the Klimple case, it talks about 2 people who just could not get along. And if you live in a condominium specifically more than any, I'm sure you're used to those 2 neighbors who just lack the ability to get along. And as you read the facts, they were antagonizing each other. And a theme you'll find here with the courts, you know, they said, look, we're not here to keep the peace just because you can't get along and behave civilly. So you'll find a lot of these, the courts really don't want to be involved in your disputes. And they're going to leave it to, you guys sort it out unless it really becomes harassing. Do you get cussed out as a board member? I'm sure you do. I've been called things that I never thought could even be created into words. But unfortunately, in Florida, being yelled at profanely and told to do X, Y, and Z in ways A, B, and C doesn't create a well-founded fear that threat's imminent. You'll get into this element of a threat that's imminent with violence. Courts are really going to want to harp on that. But interestingly, we do have a slight caveat here on harassment. I'm sure we all have had phone calls from the angry unit owner, the angry tenant, maybe the other angry board member at you. And you actually have an obscene harassing telephone call statute. And it's all there for you. What's interesting about this is, when you talk about Florida keeping up with trends in technology, they haven't touched this statute since 1995. And if anybody had cellular technology in 95, it was a vastly different technology. So this is one of those areas where you have this quirky statute that apparently if you're getting harassing phone calls from a unit owner or a tenant, maybe the other board member, you might have some recourse there. So in summary, real brief, you don't have any independent claim for harassment. You've got to get it into a specific stalking element, unless you're one of those protected classes. Understand that when you get to stalking, it's not an easy threshold to meet. But one thing you will see as we get more into this is that the stalking statute picks up the cyber communications. And that's really where we see this type of stuff burgeoning, is nobody's afraid to send an email that you would never say to somebody in person. So, we'll take a quick pause here. Shauna, we have any interesting questions? We can get into harassment because that seems to be something we get all the time.
Right, yeah. So let me see. We haven't had any come in yet, but let me see if we had any from our questions. I think you're probably good to go ahead and move on at this point, Sean, but I'm sure we'll have some more as you get into the more detailed stuff here.
So cyberbullying, where is that in Florida law? Believe it or not, it exists only in one spot, and it's section 1006.147. For those of you that live in community associations, you're saying, well, where is this statute? Interestingly, this is Florida's Education Act. The only place that you have any reference to cyberbullying in the Florida statutes is within the educational statute. Beyond that, it appears nowhere else. So what they default to instead of cyberbullying is they come into more of the cyber stalking. So hopefully none of you are staying up all night going through social media looking at your neighbors, but we all have our own interests. So cyber stalking has its own statute. So you have to engage in a course of conduct to communicate where you cause to be communicated. And it's a very broad: words, images, language, through electronic mail or electronic communication. So any type of social media gets picked up with that. You have to direct it at a specific person. So we'll come to this because this is one of the first places most of these issues fall apart. You have to access or attempt to access online accounts of home electronic systems of another person. That can be too. You start hacking emails. But as we'll get to one of the cases, it's actually very specific as to when you do this. And the most important part, and the courts will harp on this, is you have to be causing substantial emotional distress to that person, and it has to serve no legitimate purpose. So to summarize, the elements: engage in communication, use images, words, or some other type of language. I don't know what other type of language means, but that's the law. Use electronic communication such as email or social media, directed at a specific person, and it has to serve no legitimate purpose and has to be there solely to cause emotional distress to that targeted person. If you don't have all of these, you don't have cyber stalking, and you literally are going to lack relief, at least under these type of statutes. You may have relief under some of the associations governing documents stuff that will pick up down the line, general injunction type relief, but you're not going to be able to proceed under what we commonly think of as getting the restraining order from harassing, cyber stalking type communication. So what does it mean to direct it at a specific person? The courts will say it's what it means. I have to send something specifically, in this case, targeting Shauna. If I don't and specifically do that, then I'm not directing the communication at that person. So how do we communicate? Emails. We've all inadvertently sent emails. We've all intentionally sent emails. So it can be. Your emails, if depending upon what they are directed at a person. You are sending a communication to a person. And as you'll see in the case that cites there, sending about 300 emails in a month and a half, the court said, that's stalking. That's directed at a person. So that's the sort of the outlier there, is that 300 emails in a month and a half. So if you're getting a couple handful here and there, I don't think you're going to be able to get any relief under this type of law. Some examples, the Young case, one of my favorite ones. So the wife takes the husband's password to read his emails and then uses them in the divorce filing. And this is one of the ones that was talking there, intercepting communications. And the court says that changing the password and appropriate the emails were not cyber stalking because the action was not directed at the husband. You would think that would get you there, but it doesn't. In terms of emails that we get that are all disparaging and damaging, you have the Scott case, where they sent emails about Blum, his family, and business partners to 2,200 members of an association. I think we can all visualize that in our communities. The tone of the emails were derogatory and potentially damaging to the business about Blum. But none of the emails were sent specifically to him. He only learned about this after they were forwarded to him. And so they said the comments were not directed at Blum, and you don't get cyber stalking. So again, it has to be this specific communication directed at you. If they're just blasting it off to a group chat, they're not really directing at you. So when you think about sort of broad sweeping communication, social media. So, we all don't want to lose Facebook friends, but unfortunately in today's world, that seems to happen quite often. You can see here again, you're not going to get much relief from the courts under these type of laws. It is a very specific facts-intensive analysis. The courts have said posting on your own social media page aren't directed at a specific person as a matter of law. You just rant and rave on your own page about how the association's doing this, this, and this. That's not directed at somebody.
And what if they're talking about one specific person, Sean? If they're ranting on their own page, but about a specific person?
Well, so that's the last part of this. The social media basically needs to tag or be directed at a person and directed at not by content, but they look at by delivery. So that it's a very big thing there. So they look at it and say, if it's made on an electronic medium to be read by others, they're not really directed at a person. So if you run the association Facebook page and somebody just starts ranting, the board is doing this, this, and this, and just complaining where it can be read by everybody, even if they might be even singling out a specific board member, if they're just ranting at a general Facebook page and not directing it right to that singular person, you're not going to get relief in a court of law, unfortunately. You're going to have to look at other avenues to find claims that might get you the kind of protection you want. And as you can see in the third point, and I won't go into it, but you can read it, the courts sort of look at it as, this is just another form of people publicly complaining, unfortunately.
And I assume the same would go for WhatsApp. We've had a few questions come in regarding people, sending stuff to specific groups and whatnot, complaining about others in a WhatsApp. So really, there's nothing, they can do unless they're directing it at the person. They're part of the group and they're sending it to them directly.
Yeah, they're very specific on this. And, I think it's kind of like when you're board members and you get tied into the unit owner dispute, like the courts are trying to stay out of this stuff unless they really see a threat of harm coming. They realize that unfortunately in society, people are just going to be unable to get along at times, and they don't want to have to solve everything. I would say probably 25 to 35% of the appeals you'll see before a court that come out are some form of some type of injunction that comes off of this type of statute. So when you talk about substantial emotional distress, courts are very liberal, reasonable person standard, which means they're going to look at the case and they're going to look at it as the shoes of the person that's complaining. And so the courts are going to say, we are going to step into your shoes. We're going to be reasonable. We're not going to take maybe any hysterics that may be coming out of it. And so when you say, well, what is substantial emotional distress? Because honestly, having people badger you day in and day out with different communications, you'd think is substantial emotional distress. Courts don't quite get there. One of my favorite examples is the Leech case, where the wife contacts the husband's mistress by phone and makes a Facebook friend request. And the court said, that's not substantial emotional distress. And sort of summarizing, they said, you should expect this if you're in that situation. Getting threatening phone calls and text messages isn't there. They said, if you were calm afterwards. In association land, if you're a board member, they say a reasonable person would not suffer distress when a person bangs on your door and then leaves a letter and a check. So again, you can see that they really are sitting up. So you have this balcony here, and you're probably wondering, why after all this am I dropping a balcony into this? Well, you want an egregious example of where they say there's not emotional distress. You have the Paulson, where he would literally stare at his neighbor while she was sunbathing on her porch. And she made the claim trying to have some sort of injunction restraining order. And the court said, there's no emotional distress there, not severe. He didn't make any gestures. He didn't trespass onto your property. He just sat at his property and stared at you. And so you can really see where you have a very high bar to hit if you're trying to get any type of relief. Tui, he visited the office and was calling the office to check on the person's whereabouts. And they said you would not suffer substantial emotional distress there. So you're all sitting here going, is there any hope at all? And you get Robertson, where he goes to the house on 3 straight nights. He walks around the house and shines a flashlight into the house. And the court finally goes, okay, here we go. This is substantial emotional distress. But one of the keys is the guy admitted to doing it. So it's very fact intensive if you're trying to get any type of protection under the law here. And as you can see, for severe emotional distress, the courts have made it really hard to get to that level because they don't want to be in the business of this. That's really what it is at the end of the day. If you read any of these cases that come out, you'll see the courts trying to find every which way to get rid of it. You also have course of conduct, which is another part of the statute that you have to establish. Even if you get emotional distress, you have to have multiple acts that are separated by time or distance. So you have to have proof of 2 separate instances to get cyber stalking type relief. And it has to be part of a course of conduct to be legally insufficient. So you've got to have separation. Now they've held that separation can be, you have the argument in the parking lot, you get on the elevator, you get up to your unit, they come by a few minutes later, and that may be sufficient gap in time. But they really want 2 separate instances. So not one long continuous stream where you're in a continual argument with the person over, the choice of flowers in the garden out front. We've never had a landscaping dispute, have we, Sean?
Never.
And and course of conduct, if it's protected speech, you're out. So how do we have effective online communication? You can establish official sources, maintain control of the content. Understand, though, that's a lot of work on you if you really are going to take this on. This is not I'm going to establish the Facebook page and check it now and then. You really have to be diligent. You can provide useful information on a regular basis. Do not use public social media tools you can't control. You'll see that from time to time. If you can't control it, stay out of it. A big one I think we hear a lot is, unofficial sources, unofficial Facebook pages. Don't feed them. Realistically, everybody here has had children, once they have the tantrum, there's nothing you can say or do that's going to convince them the otherwise. And everything you say just is going to be piled on and used against you. And make sure you're clear on what not to publish. Don't publish confidential business. Don't publish gossip, let somebody else deal with that. Opinions, criticism, political bias, especially today's world. Don't start copyright or trademark infringement with using protected images. I've seen that. And, sort of when that pops up, people like to take pictures of the kids at the pool inappropriately. Just be very careful when you take pictures of children without parental consent. You can get into a world of uncomfortable conversations there that you don't want to be explaining to the cops when they show up why you're taking pictures of the kids at the pool. So we all know the say no evil, speak no evil, hear no evil. We sort of have the say no evil, call no evil, type no evil. So you're seeing all this, and I said it's easier to be on the defensive in these type of things. It is. One of the best ones is failure to make a credible threat. If it's so outrageous that it's unlikely to be hit, great, you're out. Free speech. Responding negatively to something someone posts online, it doesn't qualify as this. And if they're just vague with what they say. So if you're going down the road of really wanting to bring this type of claim and you have the defenses, you always have the risk that the judge is going to throw out your case. But if we have lawyer dog, maybe lawyer dog will be good and bring us the case back. So I think, before I jump into some of the more fun stuff with wiretapping, any questions that we want to jump into as we've just hacked out all that?
Yes, we had a few come in. One came in actually from the beginning that came in after it already started, so I held off. But so would the phone harassment that you spoke about in the first part require recording the phone calls lawfully in order to take repercussion against such harassers, excuse me?
That's actually a great question to jump into the next segment. I mean, I could not have planned that question better, because the next segment is recording of people.
Oh, perfect. Do you want me to go through the other ones first and then we'll come back to that one?
Well, these are only like 4 or 5 slides, so we'll get through this
Okay.
very quickly, because I think we're actually going to answer that topic and maybe some of these. So
Okay.
Audio recordings, that's what we're talking about here. We run into Florida's wiretapping statute. And so Florida's a 2-party consent state. So all parties must consent to being recorded. It covers wire, oral, or electronic communication. And so the only exception is there no expectation of privacy? So if you're recording that call where you're getting harassed, you may actually run into this wiretapping statute. So what do I talk about when I get to reasonable expectation of privacy? You're having this type of conversation in the public's parking lot and carrying on doing something ridiculous in a public parking lot, you have no expectation of privacy. But you get to the Stevenson case, and this is kind of what they look at when you're talking about the expectation of privacy. The manner in which the communication is made, what type, and where does it occur. So conversations that are in closed or secluded areas to be more likely protected. Another fun case that I liked was this Obrien case from 2018, where the wife installed spyware on the husband's computer to monitor chats with other women. And the court said that violated the wiretapping statute, because the key is when the communication is intercepted. So if it's intercepted right then and there at that moment, kind of like recording the call, then it's under the statute. If it's something you're retrieving from storage, it's a different story. So if you get that person calling, you send them the voicemail, you may actually be able to get around this to a certain extent rather than sitting there on the phone recording them. And another example, the Gilder, tape recording of face-to-face conversation without consent was a violation of the wiretapping statute. Now, there is an exception where they said, the cell phone video showed that the person knew the person had the cell phone in their hand, knew he was being recorded, tried to snatch the phone, and then made statements he was known as being recorded. And they said, that's not in the wiretapping. So as we get into, recording the calls, understand that you're going to end up into this wiretapping statute, a lot of it. And the worst thing you would have is if you get the most defaming, harassing, threatening phone call you have, and you're like, I got you, and you're recording it under the wiretapping statute, you may lose the ability to rely on any of that. Now we can go back to the questions. That was literally, I couldn't have timed that better for a perfect introduction.
Perfect. Now, if this person actually made it clear that they were recording the conversation, could they then use?
I think if, like the Smiley case makes it clear, if you're literally telling the person, I am going to be recording you, and you just make it over and over clear that you're being recorded the entire time, then I think you get there, because, the courts, as much as they don't want to be involved in this, they're not going to literally give people carte blanche. If you continually tell them, I'm recording you, and they continually just ignore and go forward with what they're doing, you don't get to sit there and turn around and go, well, you couldn't record me.
Okay. How about a Zoom HOA meeting that's recorded by a homeowner? Not like recording like we're doing right now. Just so everybody knows, we're recording this webinar, so we can disperse it to you all to watch later. But if somebody's the people on Zoom are unknowingly being recorded by somebody else, not the person running the Zoom.
So I think it's going to be a fun one to watch this unfold, because I don't think the courts have had to deal with these type of things. But you get back to the idea, my Publix example. Is there an expectation of privacy in this type of conversation? If it is a Zoom meeting that all these people have the Zoom access code to, and you broadcast it out to the world, at least your membership, we are having a Zoom meeting, here is the login credentials for it, I think you're going to run into an issue of whether there's an expectation of privacy. You're having an open online conversation that anybody with a password can come into. So, that's going to be it. And it also ties into, ironically, the next case, which is the Cohen Brothers, which is, members of an LLC's management committee didn't have an expectation of privacy with regards to participating in a telephone call to discuss financing. And yes, that's an LLC, but if you put it in the association context, members of a board didn't have an expectation of privacy with respect to participation in a Zoom meeting to discuss the operations of the association. And they also, held a very interesting rule. Society does not recognize an absolute expectation of privacy in your office or place of business. And so the key is, what's the purpose of the meeting? You're conducting the business of the company. You're not going to really run into the wiretapping statute. You're going to be outside of it. So I think given where the case law sits, if this person's inappropriately recording the Zoom meeting where you tell them don't record it, you're conducting business of the association, and if they surreptitiously do it, I don't think you're going to be able to sort of prohibit that. So the parallel to it, obviously, is video recording. And so we have our spy in the sky to record all the videos that are necessary. And interestingly, for Florida, you only really end up with video voyeurism when it comes to inappropriate recording by video. Florida generally allows video recording even without your consent. Again, it's the reasonable expectation of privacy. And so when you get to this part of the law, it really focuses on where you can be dressing, undressing, or privately exposing the body. So that's sort of the area from the video recording where they're saying that you have an expectation of privacy. Outside of that, no. Now, there's an exception for surveillance, and we know all our communities love surveillance, but you have to use conspicuous signage unless the cameras are literally obvious. And since we all like to tuck the cameras away, the signage becomes important. You also note that there's penalties for dissemination of videos that are deemed voyeuristic. So when we talk about surveillance, we're all used to these days. Where you may have an expectation of privacy is, maybe you're sitting around in front of a fireplace somewhere, but then again, it depends on where the fireplace is located. I will also note that we all like to talk about our likeness and misuse, and you're taking my pictures without permission. And so there's a law that covers that directly about likeness. But the key is the law here really is designed from a commercial context. So misuse isn't violated when it's used in news reporting, commentary, entertainment, works of fiction or not fiction, or an advertising incidental to such use. So if they are going to go on your Facebook feed and doctor up a Photoshop and send it around, that's not a misuse of your likeness. That falls into potentially just commentary or entertainment, depending upon your skill set with Photoshop. It really requires an unauthorized use to promote a product. So as you can see, when it comes to the video world, it's pretty much free game unless you're within the privacy of your home or somewhere you expect to be really secluded. So we hit the next pause point for questions, because I'm sure we have excellent questions coming.
Yeah, so we have quite a few questions. I'm going to circle back to the ones that came in for a couple of things you talked about prior, and then I'll trickle back down into the ones that you just covered. So what about a board member who creates a Facebook group titled Friends of the Association name, and limits members, but aims things on the group at specific directors? So they created a Friends of HOA, ABC, and they're only allow certain people on that page, and they talk badly about others.
I really think where you're going to end up is, unfortunately, nowhere. I think, I don't want to say you run into a First Amendment issue, because, the Constitution and community associations can be a little iffy, but you get into this whole idea of freedom of association and freedom of exclusion. And so, unless they're literally ginning up and sending off, telling the president that, yes, we're going to come over to your house and burn it down type stuff, really it's, you hate to say the really be crass about it, but you have to expect to just deal with crap. It's really the only way. You just have to have a thick skin and be willing to push through, because the law just generally isn't going to be designed here. And we'll get into some other stuff, shortly, like defamation and slander, where you have some interesting angles to potentially go. But a lot of this stuff where you want to use cyber stalking remedies and cyber stalking injunctions, it just doesn't fit. And you have such a high bar to hit these days that you just need to be able to really, like most parents, when the kids start ranting, to just walk away from it.
Yeah, it's really no different than a group of people getting together in somebody's unit or next to the pool or whatever and having the same conversation in person. You just have to, okay. If they are spreading a lie that a BOD member has done something that is illegal, how can you deal with that? I mean, can you send like a cease and desist type of thing, or how does that?
You have a cease and desist, and I don't know how many other questions we have, but that actually gets into a topic we'll get into in the defamation per se. So rather than answering that, we'll go into that. We'll go into that, but we will get into that in the defamation per se. So make sure to remember that, because that does fit squarely in that category.
Okay, perfect. Fellow board member who said that this person asked this person not to contact him and in any way. They are also a board member. So one board member trying to contact another board member, the board member says, don't contact me. It curtails board progress. Are they legally bound to this or not? So do they have to listen and say, I can't say anything, or I can't send this person an email, or how does that work?
I mean, there's no crime if you don't talk, and there's no crime if you do talk, unless you really say something horrific. I mean, you would hope that everybody has a way to function and at least move forward, but unfortunately, as we know, oftentimes we have boards that are split, 4-3, 3-2, and it's just the nature of this world.
Mm-hmm. So she can continue sending stuff to this board member if it's board business or whatever. It doesn't sound like they're sending things that are inappropriate. They're just trying to conduct business, and this board member said, stop contacting me. So really all that board member can do is delete their emails and ignore them. They can't.
I mean, we've all dealt with, the person who gets on the board and then doesn't show up or do anything. Mm-hmm. And unfortunately, that's just the nature of this world.
Okay. Going back to the HOA meetings in the Zoom, Florida Statute 720 allows recording of HOA meetings. They hold their meetings via Zoom. Do they need to tell residents that the meetings are being recorded?
When they say I'm assuming they mean the board. Does the board need to tell them if they're being recorded?
Yeah, like if they're recording I know now Zoom, when you first start it, the recording, it says to everybody, this is being recorded. Correct. I don't know. So I don't know if that counts or how you handle that.
Yeah, I like to think of the Zoom right now as we're sort of in the wild west of it. It's not a bad idea to lead off with saying we're recording this, but there's no requirement that you blurt out that it's being recorded.
Okay. If it's made known that someone's recording the other person says, I don't want you to, is that still acknowledgement that they're being recorded, therefore legal? Or does they're saying they don't want you to record them make it illegal? Do both parties have to agree or just no?
If somebody says, I don't want to be recorded, I think the way the law is designed is that's effectively going to kill your ability to record that conversation. Now it depends. If this is the video one in public, and depending upon the nature of it, you may get an exception. As you can see, it really gets very factually specific of what's communicated, how it's communicated. After you say no, do you continue talking? There's lots of nuances in there, and that's why we always said it depends. But I think in the general default, if you're recording somebody and they say, no, I don't want to be recorded, that effectively ends it on the spot.
Okay. Going back to the Ring cameras. So someone has a Ring camera that's recording audio and video at the pool. Is this considered wiretapping if none of the members, residents, guests have given consent to be audio recorded?
That's actually a creative argument, but I think you're going to fall into the wiretapping statute inadvertently, depending upon what you do with those conversations. Video recording, free game. Audio recording, Florida, we're very strict. It's a two-party consent state.
Okay, perfect.
Just so we stop having the same thing flashing.
Oh, yeah, there you go. Let's see. We have a resident who runs their own unofficial website, which is similar to our official website. We record our BOD meetings and post them on our site, which is copyrighted for the exclusive use of our residents. She then posts a synopsis, which is essentially a transcript of the meeting on her site, which is open to the whole world to see. Additionally, she constantly badmouths and harasses the board, singling out directors by name. How can we stop her?
You may have, depending upon what the action is, a copyright style claim there, but beyond that, if they're just posting synopsis, they're probably going to be okay. We're going to get, as we get into the defamation, we're going to talk about, what statements are actionable and what's pure opinion, which generally is not something you can support a claim. So I think with that, we should probably jump into the defamation aspect, because I think we're really starting to get that. So as we all know, defamation. Slander is spoken in print. Obviously, it's libel. So you don't really have a straight defamation in Florida. It covers both libel and slander. Libel, it's published false statement that's damaging to your reputation, a written defamation. And slander is the action or crime of making a false spoken statement that damages the reputation. And interestingly, in Florida, we have constitutional protection on that, freedom of speech and press, but note the highlighted. You are responsible for the abuse of this right of free speech. So the law recognizes, the Constitution recognizes that you can be held responsible if you abuse your right of free speech. So what do we need for elements when we run into the world of defamation? And this is a fun one to get into because I have it all the time. You have to show publication, which is more than what you think it'd be. It has to be falsity. The person has to act with knowledge or reckless disregard as to the falsity, at least on a public official. And if you're a private citizen, it's negligently on a matter concerning you. Go to 5, the statement obviously has to be defamatory, and 4 is where most of these die. What are your actual damages? We hear that all the time where this is being said, this is being said. Do you have actual damages? So what would a court look at if you're bringing this type of a claim? This is the type of stuff you have to think about. Whether a statement's susceptible to a defamatory interpretation is a question of law, and it turns on the gist of the statement and the context it's made. So a court's going to look at all the words that are used, and they're not just going to pick out things in isolation. They're very clear. You can't cherry pick statements out of context and say, here's my defamation. And they also note that you have to pay attention to if you give cautionary terms in qualifying the statement. So the first one, publication. This is a big one because this is an essential element if you want to go down there. Has to be to a third party. And there is a third party requirement. It's an exception for associations. So if you have a defamatory statement by one board member to the other board member in the context of a board meeting, you may not have a defamation there because, as the Holt case notes, the corporation's effectively talking to itself. So you had defamatory statements made by the chairman of the board to other members. And interestingly, in this corporation, some were non-employee directors required by law. The statements made to corporate executive or managerial employees of that entity are, in effect, it says, being made to the corporation itself and lack the element of publication. So if you're at the board meeting, nobody's there, and you're bickering back and forth between the two board members, effectively the law treats it as you're talking to yourself. So the question becomes, how far does this exception go? And no one's really tested the bounds. Obviously the statements made to the executives or managerial employees are covered. So I guess if the board member starts haranguing you, Shauna, you don't have a claim, unfortunately. But the law's not clear, who are the corporate executives and employees that may not be covered. So one of the things I always caution here is take advantage of closed meetings if you're going to have one of these. We talk about the cease and desist letters. This is one of my favorite cases that keeps me out of trouble. Is, cease and desist letter sent to the opposing party, and we CC the client all the time. They argue that's publication, and the courts go, no, it's not publication because, in effect, the attorney is your agent. And so when you have an attorney send the cease and desist letter, it's as if you're sending it yourself, just we're the agent for you. So one of my favorite, do we use the actual names for the minutes or the names that you're being called? I'm sure if we all put those in the minutes, we'd have some really entertaining minutes to have read. So you're looking at this and going, where's the damage? Well, here's where you get your damages. Defamation per se. It's where it's such a false statement that's inherently damaging that damages are presumed to exist simply because you make the statement. You don't have to prove damages. Damages are presumed, which is a substantial difference in this type of law. And the statement is going to be read as a common mind would understand it. So what do we have for defamation per se? You've committed an infamous crime. Murder, perjury, piracy, forgery, larceny. You get down to the smaller ones, robbery, arson, buggery, and if not a felony, you can start thinking where if they start accusing you of stealing funds, misappropriating funds, that could be a felonious act. And does it tend to injure you in your trade or profession? Arguably, yes, especially Shauna's profession if she's being accused of stealing money. Also, one that we're finding today is, does the person have a mental illness or infectious disease? So COVID-19, be careful with what you say out there about this type of stuff, especially as we see, trends going the wrong way. You can read the Lawnwood case. It's a punitive damage case involving a doctor, but note here, the first line, they affirmed an award of $5 million in punitive damages for damaging somebody's reputation. The courts are vicious when it comes to reputational type damages. You also, interestingly, can make defamation by implication, where you just sort of muddle the things around. And so you get liability, details right, but the gist is wrong. But you still have the same defenses. And you have statements of a pure opinion. So under Florida law, if you have a pure opinion where you make a comment based on the opinion or facts set forth in that publication, you kind of get out of it. So we had the person about the, the sort of the rogue website that was like the associations. you're probably going to get out of it if they're doing stuff of pure opinion. You can also have slander per se, which is the same type of thing. Again, they're looking at your lawful business, trade, profession. And so one of my favorite cases on this was, statement at a presentation by lawyers, which I would never do this, that to this judge, you should send boys in shorts and make sure it was always a young man. And obviously the judge was not really happy that statement got made to a group of people attending a seminar. And so the court said, hey, wait a minute, it's a factual issue whether this is an opinion or defamation. So what do we get out of this? And this is kind of a key point you'll have here on the slides. Statements of pure opinion aren't actionable. So you make a comment or opinion based on facts that are set forth in an article, i.e. you post the board minutes or which are otherwise known or available. Pure opinion, completely protected, no claim lies. If you mix opinion, then you can get there. And so they talk about what is a mixed opinion. So as again, we talk about this being a very finite point. It really depends on what the words are and where they're coming from. One of my cases that if I ever get the chance now that we can have election disputes in court was statements accusing a party of dishonest acts while holding public office. And the court said, hey, that directly impacts your character and trustworthiness to hold office. So the question becomes, if you're running for office in a community association, is that a public office that would be held to the same standard? I know we like to think of these as private communities, but you have a lot of case law that talks about associations being a little subset society of democracy. So one of these days, somebody's going to have a fun case and we're going to get to take it up on appeal and see if we can't carve out an exception. On to the fun that we talk about every day, social media threats. Again, there's a statute that deals directly with this. Contains a threat to kill or do bodily harm to such letter communications sent or member of the family or the person. So we talked about posting and tagging. You hit the O'Leary. Posting on Facebook can constitute making the threat. He wrote it out on his Facebook page and basically blasted it off to his friends. And so he, unfortunately, as you'll read there, that triggered it. Again, it hinges on how you're doing this. So this wasn't some random rant. It was a very specific targeted thing. And it kind of does, to an extent, conflict with some of the other stuff we've talked about. But you can see here the courts at the same time are trying to wade through it. Well, we don't want to solve everybody's problems and be the police agency for everybody, but at some extent, we have to control this. So written threats, remember, not threats that are not constitutionally protected speech. So if I say I'm going to go kill you, that's not protected. So the elements, you have to write or compose it. You have to send or procure the sending of it. So you can get your neighbor to send the threat and still be liable. And it's to the member of the family or the person themselves. And remember, again, general postings on social media don't get covered under this law. And with that, we run to our next set of questions.
All right. So going back just a bit, if someone states opinion to a board audience, is it sanctionable or not?
I mean, again, it really depends on whether it's pure opinion or mixed. And unfortunately, there's no blanket answer other than to say the default is always going to be, if it's something that's pure opinion based on what's out there, it's unactionable, period.
Okay. And there's no repercussions in ignoring the stalking and harassment, correct? I mean, as long if it's the only statutory requirement would be if somebody's sending letters certified to management or to the board for requesting documents and association files. Otherwise, if they're just sending somebody emails and board member emails randomly, just harassing them, they can just ignore them, correct? There's no ramifications to that?
I mean, it's the easiest one. Just ignore it.
Okay, perfect. So if residents decide to send emails with concerns or questions to board members, that's not an issue, right?
No, and there's been some cases developing along that line, recognizing that as board members, hey, look, people have the right to engage with you about the operation of their community. It may not be the most civilized conversation you're going to have, but again, they're going to default to this idea that they want free and open communication, especially if you're dealing with association operations, because that person obviously has a stake in it, and the courts sort of look at you as their elected representative. So you have to deal with your constituents, for lack of a better term.
Okay, if a board member lies to the membership, is that considered a crime?
I mean, I guess it would depend on the lie. I mean, you know, you're not under oath at a board meeting. That would be really interesting if you had to swear everybody in for an oath, like in court as a witness before you had a board meeting. That would be fun.
Let's see. Can a homeowner or a member publish association public records, meeting minutes, budgets, contracts, etc., to their own parody site, social media, if our association holds no copyright or trademark materials? Essentially, they're reposting what is available to any other member that can be gotten through, who can be found through their official records request, or probably found on the website. You know, that most websites, I know any associations we manage, we, you know, have a separate area for resident or owners, I should say, members to access, that has all that content only for owners to see. So if somebody's taking that and they're just publishing it somewhere else, is there anything that can be done about that?
I mean, I think the way the law is set up right now, the default is going to be no. You know, we're going to get into in shortly the CASA case, which I think is the one that is really an interesting one for associations, that gives them actually a little bit of a hook when it comes to injunctions. So, I mean, if we don't have, we have any other pressing questions, or should we just keep pressing?
Let's see. Can a board set standards for board members' conduct in regard to posting an email?
You can. I mean, but the question becomes then, if they don't follow it, what do you do?
Yeah.
You know, it really turns into sort of aspirational guidelines at the end of the day, you know. And again, you should want to sort of be above the fray when you're on the board. But oftentimes, as we all know, sometimes you just have to get down in the trenches and throw a punch.
And
figuratively, not literally, please.
Yeah, exactly. Yeah, please, no, not for real. I have seen where boards have made little codes of conduct, kind of like an employee handbook, you know, and they've had board members sign that. So does that hold up anywhere if they have something like that?
Yeah, I've never seen it challenged. You know, the concern you'd have is depending upon what that code of conduct says, and if you go outside of it, does that open it up some type of other claim? Maybe, you know, are you inadvertently increasing your fiduciary duty by saying you're going to adhere to these standards? So I think if you're going to do that, you really don't want them to be binding as much as possible, but maybe more aspirational goals to hit.
Okay. I think we're probably good for right now.
Okay. So defenses to defamation, as we know, the truth will always set you free. So defamatory statement is truthful. Note that a false statement must be substantially and material false, not just technically false. So they're going to focus on the substantial truth. Immunity, and this can be interesting here. It's generally a public official immunity, making statements in the scope of their duty. Does it apply to board members? Well, if you start getting into, you know, CDDs, those are elected positions, depending upon what it is, and also special taxing districts. So you may have some cover there to get to it. You know, as we were noting, conveying complaints to a board member about association-related events doesn't matter if it's crude or uncivil. As they said in the Caterino case, yelling and cursing would not cause a reasonable person to feel substantial emotional distress. And that was one of the more recent ones where you had an owner yelling at a board member. Also in defamation, mainly slander, if you want to establish, you have to say who spoke it, who they said it to, what were those statements, and the time frame. So there's a lot of detail that goes in there, which sort of fits with my thing. In this world, it's a lot easier to be on the defense in this. So if you really want to pick the fight with that rogue owner, be prepared that it's not an easy. And, you know, case dismissed. So little humor for all of you in association land. Even the Eskimos have trouble with architectural control committee issues here. So the key becomes, what are your powers, the governing documents? And as I said, the case that I find the most interesting was the Casa del Mar case, 1994. And it went up on appeal. And what they said was the president was asked to meet this person on the 23rd floor of the building. He voiced complaints about the renovation project in his unit. And when this president said, oh, look, I'm going to look into it, he tried to leave. The owner wouldn't let him depart, threw him against the wall, threw him to the floor, and uttered various threats at the president, and one of which said, you better not go because the next time you won't have a chance to answer. Trial court threw it out. The association took it up. They said, hey, look, you have an action to bring injunctive relief for failure to comply with the declaration. Their declaration said, any use or practice which interferes with the peaceful and proper use of the property by its residents. So it allowed the association to go forward. So if you're out of all these statutes, you may still have remedies in your declaration depending upon how it's drafted. So keep that in mind. And again, this is 718.303. 720 wasn't actually in 720 at that time. It was buried more in 617. But you have the same similar type of practice. So you may want to look at amending your declaration. So if you don't have the cyber stalking or the harassment elements, you can pick it up with a general injunctive provision. Again, consider the action the statement has on the operation of the associations. Don't try and pick every fight or defend everything. Avoid board members taking action on your own behalf. That's oftentimes what these people want, is for a trigger something. And I always, I made a point of my life of not living in a deed restricted community, but I did for a period of time. And I remember vividly one guy going in this townhome complex to complain to the president about the parking, and the president literally just decked the guy. Don't do that. Just don't. Amend your documents and then call me. I don't feel like having to deal with, you threatening. And so in that vein, we have, this cartoon where the guy's saying, can I help you? And the guy says, I'm from the HOA. Your mailbox is 2 shades off. Here's your first warning. And they say, what happens if you get a second warning? And they say, we punch you in the face. And so the joke is we should reread our bylaws, but don't put that in your bylaws. So again, self-help, even though it's a fantastic left hook, don't do this, please. Don't do this. Also, be cognizant of slap suits when you go down into this road. You finally say, we've got the evidence, we're making the claim. There's specific statutes that deal with. And so the slap statute basically says you can't bring a lawsuit that's without merit, and primarily because the person's exercised the right of free speech on an issue. And importantly, the statute allows the court to award attorney's fees and costs in defending this. And I've raised this defense in just litigation generally of people filing complaints. The slap suit is a tremendous weapon. So understand that if you're going forward, there's still defenses. So at the end, you better have proof of all of this, which gets back to, I'm going to need evidence if you want to do anything. If you want to do anything, document everything. You don't have to respond to all the emails, but don't delete them either. You may just want to throw them in a little folder and keep them there. Because the evidence is going to be the key. As you see, it hinges on the slightest little change of facts, which swings everything. And your ability to win on anything is going to be able to document everything and the sufficiency of the evidence. Don't be afraid to get the attorney involved. Cease and desist letters all the time. As we also know, cases are intensely fact specific as to all of these elements. So you have to really be careful, because as the one person was talking about where they say, I don't want to be recorded anymore. If it ends there, we probably run into the wiretapping statute. If it doesn't end there, we may not. So the facts can change literally second to second. Also, as I like to say, don't be afraid to get law enforcement involved. If the person literally sends you an email or calls you and says, I am going to come kill you, you don't need me. You need the sheriff. And so with that, we've hit the end of the presentation. And so we'll take all the last questions that we have.
Perfect. Sounds good. And I am going to throw up here. Let me get it back up. I'm going to put up contact information here for Sean. And this will come to you tomorrow in the email that I said we'd send out to you guys as well. So let's see. I think somebody may have missed this in the beginning. Can you define harassment and what it qualifies? And I think you said it has to cause. What was your exact words?
I mean, well, I think if you go back, I can actually scroll up and out of this. It's an element of stalking. So it's in the materials you'll be getting, but harass basically means to engage in a course of conduct that's directed at a person for no other person than to cause severe emotional distress, and it has no legitimate purpose. Mm-hmm. And if you're in association land, that legitimate purpose is really where the courts are picking up of, is it an owner complaining to you about the operation of the association? That's a legitimate purpose.
Okay, perfect. So going back to, send certified letter, requesting documents, but what if they're not requesting documents, but only a list of questions? Do you have to answer them?
Well, if you're in the condominium world, they have that specific right to send you a certified letter with specific questions that triggers a whole set of statutory obligations. HOA, that doesn't quite exist there. So again, it depends on what is, we hate to say fact specific, but what is that letter? How is it delivered? And what are the questions? Okay. And then somebody had asked for a little bit of clarification. Since corporations are people too, would they require that cyber stalking be directed
at an individual, or what if they're using the association's name rather than a specific person's name?
So they're directing the communication at the association generally?
Yeah, so they're saying Happy Acres is going to burn. Happy Acres are thieves stealing from the homeowners, things of that nature.
I don't know if you'll be able to pick it up under cyber stalking. The statutes are really geared on an individual level. You may be able, though, depending upon what it is, to pick it up under a general injunctive statute. But I think a court's still going to give you kind of a quizzical look of, well, wait a minute here. It's not really directed at a person. It's directed at, if you said an association, everybody.
Mm-hmm. All right, perfect. I think if anybody has any last questions, go ahead and submit them. Otherwise, forever hold your peace, or reach out to Sean or I later via email or phone, and we'd be happy to help you. If it's a legal question, please call Sean or email Sean, not me. No unlawful practice of law here. Or I think we might be good, Sean. I don't see any other ones. We'll give as I close here. Let's see, somebody asked for code of conduct. Annie, if you could resubmit that as a question. I'm not really sure what you mean by code of conduct. But in the meantime, we'll see if she is able to resubmit that. But Sean, thank you very much. This is very helpful. Will CAMs get credit for this? No, this is not a approved course for credits, right, Sean?
It's not yet. I don't think anybody quite has recognized where this is going, and that we're sort of at the forefront of the conversation on this topic.
Okay, perfect. Yeah, I think you answered a lot of great questions. Puts in rules, can't contact service pro. Oh, okay. So I think she's saying if you put in the rules that certain, like only specified board members can contact service providers, can they fine if somebody who's not designated to contact a service provider reaches out?
I mean, I think if you just reach out, just from a practical standpoint, if you start finding people just because they're reaching out, I think you got a problem. If they start reaching out and contracting for services without the association, you actually have the ability to hold them liable for exercising powers beyond that they have. So you have other remedies. Again, the statutes that you note here, as I hate to say, being a myth buster, they don't really function well in a community association environment. So you've got to look at other tools that you have available. It's a high bar to get to a lot of this stuff. I mean, I've done a couple of these. I filed petitions, on behalf of clients trying to have effectively restraining orders, and courts just don't like to get involved in this stuff.
Yeah, okay. And then if you did have a code of conduct, like we chatted about a few minutes ago, and had the board members sign it, and they didn't stick to it, a board member did not stick to that code of conduct, can you remove an elected director?
Yeah, I mean, unfortunately, the law right now basically recognizes only, resignation and recall. Mm-hmm. It's unfortunate. You have the code of conduct and they're not following it. Your remedy really is either convince them to resign because they're not appropriate. Maybe what they're doing is exposing the community to liability, and you can scare them that if what you do gets me sued, I'm suing you to recover those damages. But other than that, unfortunately, they can be as disruptive as they want to an extent.
Okay. Perfect. Well, we have reached the end here. Thank you to everybody who participated today and tuned in with us, and for all your questions. And Sean, thank you again for this great presentation. It's definitely timely, definitely something we all, whether you're a service provider, whether you're a CAM, you're a board member, even residents, we all deal with this. So I think you definitely cleared a lot of stuff up for us. So thank you so much for your time today and all of this great information.
Again, if anybody has questions, feel free to contact me, because this is an area where there's more confusion, there is certainty.
Yeah, absolutely. And as I said in the beginning, we will email, or I will be emailing out the presentation that Sean gave, as well as a link to the recording, the video. Sean, you're being recorded right now.
I give my consent.
You give your consent? Okay. We'll send that all out tomorrow, and then also have Sean's contact info. So feel free to reach out if you guys should need anything else. Thank you so much, and I hope everybody has a great afternoon.
Thank you.